Thanks a lot. So I want to explore a bit further what regulatory chill looks like in reality and what it'll mean for people, as opposed to it all being kind of highfalutin treaties and investor court system. So just to take a current issue, which is the issue of data centres. We know that we may have electricity blackouts this winter. We know electricity prices are going through the roof, primarily because of international factors, but also because of the fact that data centres currently use 11% of all the electricity produced in this country. By the end of the decade, that's going to be up to 30% and continuing. So in the event that CETA is ratified and that a Canadian company is seeking to build a data centre in Ireland, let's say that government policy changes in line with People for Profit's bill and we say no more data centres, it's unsustainable. Isn't it the case that such a Canadian corporation could then sue the Irish state in this investor court system for quote unquote indirect expropriation? Let's say that they've bought the land, they're preparing to go, and then we say no more planning permissions for data centres. They could take us to the investor court system.
It's always the case, Deputy, that somebody can sue if they feel that they have been subjected to expropriation or confiscation. If that were to happen now, potentially any company, an Irish company, a Canadian company, a company from Sri Lanka could sue. They would just do so through the national courts or through existing mechanisms. This is just a new mechanism and one that we believe is fair and transparent and more efficient.
Yeah, so they could sue in the investor court system.
And they can sue now in the national courts.
Correct. So I don't know if they're being deliberately obtuse about the difference between national courts and investor court system. Do you accept that there is a substantial difference in that the national courts rule on the basis of Irish and European law, which can be changed by different parliaments, different governments being elected? The laws can be changed. Even the constitution can be changed. But the investor court system that will be set up under CETA will not be subject to democratic change. They will simply interpret the terms of CETA. I've outlined the very broad definition of indirect expropriation. Do you accept that that is a very fundamental difference? It's not just all the same, national courts, investor court system. There's a fundamental difference between the two.
I'm not saying it's all the same, Deputy. What I'm saying is that where there is an international agreement or an international treaty, it is standard that there will be some sort of mechanism for adjudicating disputes where they occur. And, we have the European treaties and therefore we have the European Court of Justice and the European courts. We have international courts. And when it comes to any international treaty or agreement, we tend to have some form of arbitration or mechanism to settle a dispute. And in that sense, I don't think it's something that is new or fundamentally different. I accept that accept that investor court system is different to a national court, but I don't think it is fundamentally different to what exists already under any number of international agreements, international treaties, where there is a court or dispute resolution mechanism.
Oh, there's no question that there's plenty of very bad investor-state dispute settlement mechanisms out there. There's no question about that. That's where the 1,000 Canadian corporations are taking these cases worth hundreds of billions of dollars, and they've been widely criticized. So there's no question that these things already exist out there, but this is a new development in terms of the EU and Canada. And as has been said by you and others repeatedly, this is going to be the model, and it continues the same bad practice of a parallel justice system which only corporations can access. That's the fundamental point, and it's not subject to change by democratically elected politicians. It's simply, we have this CETA agreement, and that's what they'll implement.
Yeah, Deputy, I appreciate your intellectual honesty in this regard. You're against these mechanisms, full stop.
Against ICS mechanisms, absolutely, yeah.
And it's your view that rather than having free trade, that trade should be managed by states, and that's fine.
Rather than having parallel justice systems for corporations and individuals should be able to take cases, as they currently can, as you have stressed repeatedly, in national and European courts, that we don't need a special corporate court process.
But the false impression being created, and I see this in the emails that I'm getting, and I see it in the emails that TDs are getting, is that somehow ratifying CETA for the first time will allow Canadian companies or foreign companies to sue the state and state agencies for discrimination. As you point out, that happens all the time. There's hundreds or thousands of cases, so there's no change in that regard. And secondly, the argument being made and the idea being created somehow is that an investor court system is something new, that this is a new departure. It's not. There are loads of those mechanisms that already exist and are in operation now.
But that Ireland is not subject to. So you said no change in that regard. And again, I bring you back to the point. You're trying to deny the fact that there's a fundamental difference between a national court process, which anybody can access, and a parallel court process that is only accessible to investors and corporations. There's a very fundamental difference, which you're very much at pains to suggest it is all the same. You know, after saying no, you accept it's not all the same, then you said there's no change in that regard. If we ratify CETA, Canadian corporations can sue us in a private administrative tribunal called an investor court system, which they can't currently sue the Irish state in. That is a fundamental difference. The difference between IRES REIT taking a case against the state in an Irish court, because democratically, we can change the laws. We decide what the laws are, elected politicians, versus their ability to sue the state in a private tribunal.
No, well, what I was saying, Deputy, is that there is a difference between an international court and arbitration panel on the one hand and a national court. Of course there is. But what I'm also saying is that when it comes to international treaties and international agreements, it's fairly standard and commonplace that we have international courts or we have international arbitration mechanisms. And this is no different to that. It's not a new departure in that sense.
Can you tell us, is the Irish state party to any other treaties which involves an investor court systems?
There's obviously the energy treaty, which involves some things on those lines, and we're subject to other international courts, for example.
What other international courts that are similar to the courts that will be established by CETA?
For example, the European courts, where we agreed under a treaty.
You're not seriously claiming that this is the same as the European courts.
I'm not saying it's
You've just
same.
accepted that it's not the same a minute ago, and now again you're trying to compare them. So this is a fundamental departure.
Deputy, you keep saying that I said it the same. I didn't. What I'm saying is that where there are international agreements, where there are international treaties, like the treaties that we've concluded with the United Kingdom, for example, the TCA and the treaty on the protocol, you have to have some sort of mechanism to adjudicate disputes, and that's where international courts and international tribunals come in, and this is in that vein.
Thanks,
I'm not saying it's the same. I never said it's the same.
Thanks, Deputy Moore, for your time is up.
But the implication that some people are making is that somehow ratification of CETA for the first time allows Canadian companies to sue the state or take us to court for discrimination. That's not the case. And
in a private parallel court process that is only accessible to investors and corporations, that is new, and that's a fundamental
change. Thanks, Deputy Moore.
Deputy, if you read the emails that people are getting in their inboxes from constituents who may be concerned about it, somebody has clearly and deliberately given them the wrong impression. They think for the first time it's going to be possible for companies to sue the Irish state. That's not the case. This has been the case since companies and courts began.
I think you're giving the wrong impression by suggesting that things are all the same. You keep trying to deny it, then you return to making the point.
You keep saying all the same. That's not what I've said.
Sorry, your time is up there, I'm afraid. The next person that's indicated to speak is Deputy Louise O'Reilly, and you have 7 minutes.